So today I will talk about formal methods and the law. So lawyers are increasingly being told that artificial intelligence is going to change the way that law is practiced, that lawyers are going to lose their jobs to AI, that AI is going to transform access to justice, and more. Overwhelmingly, though, the AI that's being spoken of here is systems based on statistical learning. E-discovery programs that sort through vast amounts of documents to find ones that might be relevant to the case at issue. Machine learning programs that are able to predict the outcomes of cases fairly well and then can help lawyers decide whether to settle a case or to pursue it. And it's true that data-driven AI is very powerful and will change the landscape of legal practice, although some of the claims, of course, are, let's say, overblown. Relatively little attention has been paid, however, to what some dismiss as first-wave artificial intelligence, rules-based AI, involving formalization of a system of rules as opposed to data-driven AI. And what I'll argue today is that there is untapped potential in formalization and rules-based AI, at least for certain parts of US law. So after this introduction, I will distinguish between sources of law in the United States, specifically between common law and statutory law. I'll talk about why formalization is particularly useful when it comes to what I'll call statutory law. I will propose a particular approach for formalizing statutory law, and then I'll raise and I hope respond to some common objections to my proposals. So when one thinks of where to find the law, what is the law, you might think of looking at a statute or in a code book, but in fact, much law in the United States is made by courts through the common law. Common law is a body of law that arises from the decision of courts over many years in many different jurisdictions. Later decisions build on earlier decisions. Put another way, the early decisions shape the later decisions. And so court cases are a major source of law in common law countries, of which the United States is one. Everyone agrees that common law reasoning is a puzzle. When students are taught to think like lawyers in their first year of law school, what they're taught is common law reasoning. Books on legal reasoning are devoted almost entirely to common law reasoning. How do courts reason from one case to the next? Is common law reasoning from analogy? How could common law reasoning be modeled? How can it be justified? These are very hard questions, and predicting the outcome of a case that will be decided by a judge based on some kind of reasoning from earlier but similar but not identical cases is difficult. Common law uses case-based reasoning, and case-based reasoning is well suited to database approaches. So machine learning programs may be good predictors of case outcomes. In contrast, some law in the United States, including tax law, is primarily based on statutes, laws passed by legislatures, and regulations, rules promulgated by administrative agencies that clarify or expand upon statutes. I'll call this statutory law for short. And it is with respect to statutory law that formalization and rules-based AI has, I believe, the greatest potential. Much of the complexity and difficulty of statutory law comes from the large number of rules involved and from understanding the interaction of rules whose language is relatively clear. So why formalize? I'll discuss two benefits of formalizing statutory law. First, formalization can help root out and eliminate unwanted ambiguity in the law. And second, formalization will help with the project of using artificial intelligence to reason about the law. And throughout this presentation, I'll use tax law to provide examples, but I don't have any reason to think that tax law is different from other types of statutory law. So first, structural ambiguity. So formalization can help avoid unwanted ambiguity in the law, not in individual terms, but in what I'll call structural ambiguity. And I'll use as my example here the Internal Revenue Code. The code and its accompanying regulations are notoriously complex. Sometimes its complexity is attributed to its size, that is the code and regulations. They posed for me a couple of days ago in my office. That's a lot of rules. But part of its complexity is due to its structure, which is in turn due to the code's many interlinked sections, to the dependencies among the various sections of the code. Much of the complexity of tax, in other words, comes from understanding the interaction of rules whose language is clear. Formalization can help root out unintended ambiguity in the structure of the law, in the formal interrelation of the parts of the code. So I'm going to discuss one particular example of structural ambiguity, what I call the problem of definitional scope. In a number of places in the code, a general rule uses a term. The term is defined, and then in a separate section, there's some limitation imposed on the term. Then the term is used again in another rule. So the problem here is that in the other rule, it's not clear whether the term includes the limitation or not. So when you call back to the term, are you calling back to just what's in the definition, or are you calling back to the definition and the limitation? You could think about it both ways. There's really no clear answer, and I'll give you an example that shows that there's no clear answer. So here's an example of the problem of definitional scope in the Internal Revenue Code. And it's the provision regarding home mortgage interest deduction. I'm going to describe the permanent language of the statute. Some aspects of this provision are modified for the next 7 years by the new tax law that was passed. But that new provision expires, and the point about the structure of the statute remains. And in general, if you are taking tax advice from a presentation at a computer science conference, you're probably doing it wrong. So, all right, so anyway. Okay, so here's the section, and we're going to come back to this as well a little bit later. So in general, interest payments are deductible, but personal interest payments are not deductible, and personal interest payments are defined by exclusion. And one of those exclusions is qualified residence interest, and this is commonly known as home mortgage interest. All right, what is qualified residence interest? It's interest which is paid or accrued on acquisition indebtedness or home equity indebtedness. All right, now here we go. So acquisition indebtedness is indebtedness that is incurred for this particular reason, acquiring, constructing, substantially improving any qualified residence, and is secured by that residence. And then we have the separate limitation provision in blue that says the aggregate amount treated as acquisition indebtedness can't exceed $1 million. Okay, so for example, you have someone who purchases a $1.5 million home, entirely debt financed. They can take deductions with respect to the interest on, under this provision, only $1 million of that debt. However, the statute also allows a deduction for another type of interest, deductions on the interest of what it calls home equity indebtedness. So this is indebtedness that's not acquisition indebtedness, and then it's subject to some other requirements, which I won't go into. The key point here, though, is that it uses the term acquisition indebtedness again. So here we have our problem. The problem is when the home equity indebtedness uses the term acquisition indebtedness, does that refer to just the part in red or the part in red and the part in blue? Okay, so to be home equity indebtedness, a debt needs to not be acquisition indebtedness. And to show that something is not acquisition indebtedness, at least one part of its definition fails to hold, has to fail to hold. If the only parts of the definition are that it has to have this purpose and it has to be secured by the residents, then in order for something not to be acquisition indebtedness, it has to fail one of those prongs. But if the less than $1 million limitation is in there, then it can fail any one of the three and not be acquisition indebtedness. So this actually was an issue in a tax court case. This exact thing was an issue in a tax court case. So mostly people look at this and say, don't be ridiculous, the answer is obvious. But when I ask, well, what's the answer? They will say one of two things. Like, the answer is obvious to everyone, but it's not obvious in the same way. But I feel confident that it's ambiguous because the IRS initially took the position that the $1 million limitation was not part of the definition, and the US tax court agreed. And then the IRS disavowed that win and issued a ruling that said it was part of the definition, and then the tax court later adopted that position. So there really was truly an ambiguity because the IRS and tax court took different positions at different times. And the resolution of that ambiguity resulted in different substantive outcomes for the taxpayer. This illustrates the problem of definitional scope. It's just not clear what to do with that $1 million limitation. Now, it's true that what we have here is, I won't say just, but what we have here is bad drafting. I mean, it's not hard to change the drafting so that we're clear. So put the limitation as part of the definition of acquisition indebtedness, or if that's not what you want to do, be absolutely clear here and say it's home equity indebtedness is any indebtedness other than acquisition indebtedness as defined in, and then say one little I so that we know it's only the red part. I mean, it's not like this is an impossible problem to fix, but the point is, you could have fixed it with better drafting, but you also should have caught it when you drafted it. And this is not the only place that this form of drafting appears. So these types of ambiguities due to the structure of the code, can be avoided if you try to formalize the provision before it is enacted. And they can be located by people who are formalizing the code after it's enacted. Obviously, there's a range of ways to formalize these provisions, but you could start by just, if you wanted to not have the $1 million limitation, then don't put it in, or do put it in, but you have to make that decision when you're defining the term and you're formalizing it. So the formalization would be helpful even if it weren't made public, because it could help drafters avoid ambiguity. And ambiguity can create a range of problems. It increases the compliance burden because taxpayers have to spend time and money to determine what the law means. It creates burdens for the IRS, which has to help taxpayers comply. Ambiguous provisions lead to increased audits, more protracted audits, even litigation. These are all additional costly burdens on taxpayers and the government. Congress has acknowledged the problem of unintended ambiguity, and it has mandated an annual tax law complexity analysis, which is to include provisions where the law is uncertain. So even if this weren't public, it would still be helpful. If the formalization were published along with the legislative history, however, the formalization could be even more helpful. It could be helpful if the statute is particularly complex, because readers of the statute who want to understand the statute structure more clearly could resort to the formalization. And this could be helpful even in the absence of ambiguity. The formalization wouldn't be binding. It wouldn't be the legislation. It could be given the same weight or lack of weight as any other legislative history. So formalization alone, just formalization without taking it any further, I think can be useful. More can be done with formalization, though, than simply avoiding ambiguities. Formalizing statutes would help with the project of applying artificial intelligence to statutory law. Now, to be clear, by artificial intelligence, I mean a program that can reason in some sense about the law, not programs like TurboTax. TurboTax comes up all the time when people are trying to, they say, oh, well, you know, rules-based AI is good for some things, like TurboTax. What TurboTax is, so far as I can tell, TurboTax just takes the tax forms and puts them on the computer. And that's not what I'm talking about. Now, this is in no way to make light of what TurboTax does, because I don't want to make light of tax forms, which are actually kind of incredibly cool. They're kind of proto-formalizations of the code, right? They're these forms that you just put in numbers and follow the directions, and then it spits out at the end a number that's an implementation of the law. So they're really cool, and I'm not trying to say anything against tax forms, but TurboTax is not. When they describe how TurboTax works, sometimes people are kind of just making up stories. Oh, they got these tax lawyers together with these accountants, and they sat down. And look, TurboTax has been around for a long time. If TurboTax had managed to get the tax code into a computable form, and then that would be a huge deal, especially if they had done it 15, 20 years ago. They just took the forms and put them on there, which is great, but it's not what I'm talking about. Okay, consider the possibilities that arise, though, if the actual law is formalized. So here's an example, tax shelters. What is a tax shelter? Difficult to define. The code says that a transaction is a tax shelter if the significant purpose of the transaction is the avoidance of federal tax. I like this definition by Michael Gratz. It's a deal done by very smart people that absent tax considerations would be very stupid. So some tax shelters achieve their results by giving legislatively unintended meaning to words, calling something debt that Congress really wouldn't want to be debt. Some tax shelters just work through falsehoods, inflating the amount of a charitable contribution, for example. These are not so interesting. But some tax shelters work by chaining together disparate rules to create the possibility of tax avoidance. And here I think artificial intelligence could come into play. Because just as artificial intelligence is used to find opportunities for financial arbitrage, analogously, I wonder if artificial intelligence can be used to find opportunities for regulatory arbitrage through increasingly complex chaining shelters. So one imagines a computer shuffling through different permutations of tax law to find ways to bring disparate rules together to create tax avoidance. If the corpus of tax law is made available to artificial intelligence, that is, a computer could just sort through various permutations of law, regulations, and fact patterns to find opportunities for regulatory arbitrage. A program might be able to find situations in which two transactions with identical cash flows receive different treatment under the tax law, or it might be able to find situations in which the same transaction receives different treatment under the tax law in the future than it does today. If such a program is developed, the marginal cost of developing a tax shelter would essentially drop to zero. And as the IRS shuts down one shelter, another shelter just rolls right in to take its place. So the potential here seems staggering. I'm not sure whether I mean that in a good way or a bad way. All right, so that's one, another possibility for formalization. Okay, so if we're going to formalize, how to formalize? So this is at least two questions. One question is who's going to do it? One possibility is humans. Maybe drafters of legislation could formalize proposed legislation. Even if the current staff wouldn't be able to formalize the legislation, there's no shortage of people who could be hired for the purpose of formalizing proposed language. So I sort of imagine, I've often imagined someone hiring me to do this, and they put me in a room and they just keep sliding pizzas in. and I just like formalize all the tax code that they give me, and then I go home at 5 o'clock, and I would take that job. All right. All right. But you could have the formalization done by a separate group, maybe within the Joint Committee on Taxation or by some other nonpartisan expert office. Legislative drafters generally are, believe it or not, I know this seems unlikely given the past few months, but generally legislative drafters are nonpartisan and very sophisticated. And while formalization might initially look daunting, it's really not that hard to grasp. And even if the drafters couldn't generate the formalizations themselves, I am confident that they would acquire the ability to interpret the formalizations. Now, that said, the tax code and regulations are vast. Even if humans could formalize the statutes going forward, to formalize the whole tax code and regulations by hand seems unlikely. So if it could be formalized using, for example, natural language processing, that the task would become manageable. I worked with some computer scientists to try to apply natural language processing to the tax code, and candidly, it didn't go that well. The language of the tax code has a very complex structure that was not conducive to using natural language processing to extract the rules. I'm definitely not an expert on natural language processing, though, so I will not be able to answer questions about that attempt, but I can direct you to that paper if you're interested in more. So that's the sort of how formalization question from one side. But there's also the question of how to formalize statutes in the sense of using what formalization. So I'm going to give you my view on one logic that I like, but I think this is a question. I think this is kind of an open question. I've also seen an argument that temporal logic is better for this. So anyway, I think this is an open question. So here's one I like, though. I like non-monotonic logic as a way to formalize statutes, and I'll explain why in a minute. Let me give you this example first. There's a number of ways to formalize non-monotonic logic. I've focused on a variant of default logic, so let me briefly go through that and show why I think this logic is well suited to formalizing US law. So we have a collection of propositional formulas that you can informally think of as a world, a collection of default rules and some relationship between the default rules that establishes the relative priority of the default rules. Here I've used an order of application approach that is associated, a modification of that's associated with Bruca and Eider. So each default rule takes the form of prerequisite justifications and a consequence. The idea is that given some A, if the B sub i's are consistent with what's already been accepted, then you defeasibly conclude C, and these are all first order, A, B, and C are all first order formulas. So a default rule is normal if the justification is logically equivalent to the consequence. It's prerequisite free if A is a logical truth. So basically what we have is a supernormal default rule can be identified with its conclusion. And for reasons that I won't go into now, I think statutory rules are best considered supernormal. And I'll use a modified approach here that's appropriate for supernormal rules. And also there's a finite number of laws. This is sometimes the thing that prevents people from becoming interested in this problem. I say, well, what are we doing? I say, well, we have a finite number of laws. A finite number of laws, this question is trivial. We're not going to discuss it. All right. But, bear with me, notwithstanding that this is trivial. All right, so we're really going to take a really nice, simple approach here. So the basic idea, and I think I actually won't go through this part in detail, but the basic idea is that we're going to consider the default rules from strongest to weakest, And we add to the belief set the rule that we are considering at each stage if that rule is consistent with already adopted beliefs. So we're just going to check the most powerful active rule and throw it in there. If it's consistent with what we've already adopted. And then we're going to have a preferred extension, and that will be the set of rules that the reasoner should adopt. And that's you can have a preferred extension. Basically, so C is the union of all of the E sub A's, and so when E, basically it's a sort of fixed point idea, and there's always going to be exactly one preferred extension. Okay, so this is the basic idea. So let's look at a legal example to have an example of why this captures the idea well, and then I'll talk to you more about why it's generalizable and I haven't just cherry-picked the one section that happens to capture this well. Okay, so let's look at 163 again. So remember we had our first rule that interest was deductible. What does it mean that it's deductible? Why do we want it to be deductible? It's deductible because it reduces the tax equals the base times the rate. So if something's deductible, it reduces the base. So if you have a deduction of 800, it reduces the tax by 21% of that. That's, if you're a corporation, that's the marginal rate for corporations. So we like deductions. That's the point of this. Deductions reduce tax. Okay, so we know that in general, interest payments are deductible. But there's our second rule, and our second rule is more powerful than the first rule. And we say if an interest payment is personal, then in general it's not deductible. And so then we have a third rule that's stronger than the second rule, and that if something is qualified residence interest, the home mortgage interest that we looked at, then it is deductible. So we have an ordering to these rules as well. Remember the less than is it's more powerful. So D1 is the most powerful here. And there's also two rules that are certain, essentially they're definitional. And that's that personal interest payments are always interest payments and qualified residence interest payments are always personal. So here is our scenario. Okay, so see how these rules combine. You take in a situation in which we're going to add to W that it's personal interest, and then that there's no evidence that it's qualified residence interest. Okay, so the first rule to consider is delta 1. If it's qualified residence interest, then it's deductible. This rule is consistent with the logical extension of W, and so we're going to throw it in there. It might seem strange to throw it into what we believe, but it actually is. Turns out not for this, but for other reasons it's important because it's going to prevent some kind of strange things from arising later. Not during this talk, but believe me, they would arise if we did not put that in. All right, so then we consider delta 2. If it's personal, then it's not deductible. This rule is consistent, so we add it as well. And then we check delta 3, which is, turns out, not added. It's not consistent. There's no more rules to apply. We have our preferred extension. We can, and not deductible is in that preferred extension. So the interest payment in question is not deductible. So that's how this would go. Okay, so maybe I just got lucky. Why am I doing this? Why default logic? Default logic is equivalent to standard logic. And I could just do these two rules. Why am I proposing that we use this different logic? My claim, though, isn't that this type of logic is required to represent statutory reasoning, but that it's preferable for formalizing the code. And this is a practical claim. It's entirely pragmatics based. And it's based on the claim that because of the way these statutes are drafted, this default logic more closely tracks the structure of the code itself. It was very easy for me to extract those 3 rules from the code the way it's written. It is less easy for me to build these. So, first of all, maybe it's a crazy coincidence, and second of all, like, who cares if it's easier to extract those rules? Okay, so I don't think it's a crazy coincidence. This is how the House Legislative Drafting Manual tells drafters to draft, a general rule and exceptions. So that's kind of highly suggestive that we could be using something like the default logic. And that's also how the Senate Legislative Drafting Manual tells folks to draft. So this is a structure that we can expect to see. So who cares? Well, because default logic tracks the structure of statutes and statutory drafting, it's easier to convert statutes into default logic than into standard logic. And if we have, if we base our artificial intelligence on default logic, it's going to be easier to encode statutes and extract information from statutes than artificial intelligence based on standard logic. And it's easier and less expensive to create programs meant to apply the law if the programs are written in languages that more closely track the actual structure of the law. So you can tag certain rules with priorities instead of having to manually combine the rules to get the right answer. And if formalizing the statutes is relatively easy, drafters may be more likely to use formalization to check the structure of statutes, which might help avoid errors and unintentional structural ambiguities. There are, of course, objections to this. First, it may seem too costly to formalize the language of statutes, and the payoff may seem to be too small. So take the example of the problem of definitional scope described previously. This problem occurs multiple times in the code, but not that many times. Maybe this seems like a minor problem. At least one instance of this was eventually taken care of by the IRS through guidance. Would avoiding this really have been worth hiring, several extra staffers to translate proposed language? But I think when you weigh the costs of formalizing against the costs of not formalizing, it's not so clear-cut. The ex-ante cost of avoiding unintentional ambiguity may be less than the ex-post cost of dealing with that ambiguity. So the ex-post cost includes, as I've mentioned, not only litigation that could have been avoided had the ambiguity been absent, but also increased compliance costs, because even if you don't litigate, you have to spend time and resources to resolve the ambiguity, as well as audit costs. Formalization would join pre-enactment analyses, such as cost estimates provided by the Congressional Budget Office, whose benefit is deemed to outweigh their cost. And also, drafting practices aren't static. As formalizers tried to formalize various proposed legislation, they could go back to the drafters and ask them to resolve ambiguities. The drafters might learn eventually how to write language that is more easily formalized, clearer. And the cost of formalization could thus become lower over time. I was thinking last night about other things that are in the code that really don't cause any real ambiguity, but are just annoying. Like there's a lot of times when they define what to do if something is greater than something or something is less, but they don't tell you what to do when they're equal, and you can figure it out. It's not hard, but I don't know, it's sloppy. But I could not really put that in here as like an advantage of formalization, because it's like an advantage of formalization is it would cause the code to annoy Lawsky less. So that's not really an advantage. Okay, so second, one might object that Congress may sometimes wish to leave the structure of a statute or the meaning of a term in a statute ambiguous. So there is definitely advantages. There's definitely advantages to ambiguity. Congress might decide to leave a statute ambiguous because that's the only way to get the law passed. Or Congress might decide to leave a gap in a statute to be later filled by an administrative agency or courts. So ambiguity can serve a purpose, whether that's permitting a vote to go through or allocating decision-making to a branch Congress perceives as more competent. For example, the details of a provision might be better filled in by an administrative agency with expertise, such as the Treasury Department, or a court might be better able to weigh competing concerns. But formalization would not prevent drafters from crafting legislation that is ambiguous. So on a most basic level, Congress, you can always leave a term that's just like a logical primitive, so that any meaning would have to be filled in by another party. I think that is leaving terms ambiguous is the most common form of ambiguity that is intentional. I am, let's just say, highly skeptical that there is intentional structural ambiguity in the code. I am highly skeptical that that is the case. But if Congress wanted to put in intentional structural ambiguity, that would be fine. Faced with a structural ambiguity, the formalizers could publish alternate formalizations and indicate that it was unclear from the language of the legislation which was correct. Or they could choose not to publish a formalization of that portion of the statute, but publish an explanation of why they could not formalize it. So formalization wouldn't prevent drafters from including ambiguity, but it would hopefully help prevent them from including ambiguity unintentionally. So while there may be benefits to ambiguity, I do not think that there are necessarily benefits to unintentional ambiguity. You should at least make the choice whether the ambiguity is there or not. So finally, I may be proposing a very unrealistic vision of drafting. So consider the tax bill that was recently passed. That bill was thrown together in mere weeks. The bill that was passed had actual scribbles in the margin. So this is an actual picture of the House bill that was passed. So the idea that someone would carefully draft legislation, which would then be formalized and then revised because of the formalization process, seems really unlikely. So considering they didn't even have the time to type up the English, right? Much less engage in some back and forth formalization. Okay, so this is depressing. If we take the political process as a given, then at least for some bills, yes, it would be impossible to formalize the language in advance. Maybe though requiring, I don't know, maybe requiring formalization, having it become part of the process, maybe it would start to seem, well, no, I was going to say maybe like you have to get like a joint committee on taxation estimate of how much the bill will cost before things go forward. So they had to sort of wait for that. I don't know. I was going to say maybe it would become something that they felt like they had to wait for and it would slow things down. That's probably too optimistic. But look, even if for some bills you can't formalize the language in advance, there's still benefit to formalize the text of the act after it's passed. Post-passage formalization wouldn't help the law avoid unintentional ambiguities, but it would at least highlight those ambiguities and provide a roadmap for those trying to comply with the law and those trying to enforce and interpret it. It might often, there are technical corrections bills passed after something is rushed through like this. Maybe these ambiguities could be addressed in the technical correction bills. And the post-act formalizations would remain extremely useful for artificial intelligence applications. So I've argued that at least some statutes are usefully formalized. I think the questions that remain are basically how should they be formalized, both in the sense of in what manner and also in what form, and then once they're formalized, what can we do interesting when it comes time to analyze them computationally. There's some work on these questions, and people have been formalizing statutes on and off for the last 50 years. And there are some people who are still working on this, on the computational law side of things, but I think it's gotten relatively less attention, and so there's a tremendous amount of interesting work that remains to be done. And so with that, I look forward to your questions, comments, thoughts.
Sure. So that's an intriguing talk. Thank you very much. As I try to apply the principles in this talk to situations I've encountered in the past, I do have a question. I do have some questions. It seems to me that it's not clear to me how you could make everything in the law ambiguous. In particular, here's an example that struck me. As you know, a patent is invalid if it's obvious. And it's not, the courts haven't formalized obviousness. It's fairly ambiguous in practice whether a patent is obvious or not until it's actually going to trial and been, determined obvious or not. And I guess the question is that an example of intentional ambiguity? It seems to me that if I fit it into the conceptual framework that you're talking about here, that's something that you would leave, that's an example of ambiguity that you would leave to the court to apply at the case at hand as it arises. Is that?
Yeah, absolutely. And that's an example of decisions that are made through common law that I don't think would be particularly susceptible to this kind of formalization. That question, like many other questions, is a question that has been given over to the courts to decide. And that's the nature of living in a common law country, and that's how it goes. I mean, there's nothing.
I see. So what this endeavor would imply is that you would have to go off and formalize part of the law.
Absolutely,
and
yes.
Then have that be, okay.
Right. So in the U.S., there's actually not, on the federal level, I should say, there's actually not that many parts of the law that I think would be susceptible to this. I think tax law would be. Okay. Bankruptcy law is also heavily codified in the U.S. I think bankruptcy law could be. There's not that many other areas of the law in the U.S. that have rules that are sufficiently complex that I think there would be payoff for it. So, for example, take contract law. Mm-hmm. We do have the Uniform Commercial Code, which this is not federal law, but it's been adopted by all or almost all of the states. Like the UCC is like not that hard to read. The action there comes from court decisions. And that's not, I don't think that kind of thing is susceptible to this type of, I don't think it's susceptible to this. I think that the common law decisions is, I think those are really hard to predict, and I think they're more susceptible to maybe to machine learning or something like that.
Got it. So I guess, one last question if it's okay. Is it okay? Yeah. So what percentage of the law do you think this would apply to?
In the U.S.?
Yes.
I don't know about percentage. I would say, not that much, but the cost of the law that is enforced, like the costs are very high. The cost of, for example, enforcing and complying with tax law is extremely high. So I think it would pay off. Mm-hmm. But I don't think it would pay off. I can think of lots of areas of law where I do not think it would pay off. Criminal law, patent law. I mean, the list is long in a common law country. And I think that's why this hasn't gotten as much, one reason this hasn't gotten as much attention as the machine learning stuff.
Okay, great. Thank you.
So it seems like the central analogy here is that code is spec, so we can apply the insights we have in the PL community to legal reasoning. But going the other way, I feel like legal scholars have much more experience crafting specs in ambiguous language, oftentimes adversarially against better funded people who are just as smart as they are. So my question for you is there something you can teach us about writing specs?
Is there something I can teach you about writing? I doubt it. No, that seems unlikely. Unless you're way more adversarial than I thought, which I guess is possible.
I think in fact we are very adversarial. So for example, like recently, so Andrew likes to talk about this a lot, I guess, is that recently we usually when we specify CPUs say we have this sort of semantic notion, but we've recently discovered in the news, you might have heard there are like timing attacks that are a huge deal and costing people a lot of money because we didn't think that this was sort of part of the spec.
Yeah, I don't know. I mean, the thing about law is I mean, this is part of, frankly, what I found frustrating about most law, which is why I retreated to tax law, is that so much of it is about taking advantage of human weaknesses and interaction. When you read a law case, I had a dark 3 years where I taught contract law, which is a common law course. And it was, by the third year, I was saying things to my students like, this is just nonsense, it doesn't make any sense. I'm throwing away my lecture now, I'm never teaching this again, and I would, put my lecture in the garbage can. It was a horrible experience. But it really is that when you read a case, a common law case, you can often tell the outcome of the case from the first sentence of the statement of the facts. Just the way the judge decides to write the story. So this is a completely different realm of opposition, I would say. Yeah.
Thanks. So let me sort of follow up on that with a question from Slido. We also have some people sort of participating remotely. So do you think that there are other sort of related application areas like perhaps industries, industrial applications,
Yeah.
or perhaps maybe regulations
Yes.
that can be formalized?
Yeah.
more
So
quickly?
there are a lot of areas that are very regulation heavy that I think could benefit from formalization, and there's also at the state level, I think probably much more regulation that is susceptible to this. So one possibility that's very regulation heavy would be securities regulation. I think that could benefit from formalization, and because there's both state and federal regulation. If you could combine those, that would probably be hugely useful. Environmental regulation, I think, would probably be useful to formalize. Those would have different kinds of benefits. I think the main benefits there would be reducing compliance costs. Tax may be unique in the sense that formalizing it could actually be a source of profit, and that's not a good thing, right? I mean, but it's not like you're going to find securities regulation shelters. That's not really a thing. But it's still, they still would be susceptible to formalization. These heavily regulated areas, at least you could reduce compliance costs.
So from the sort of government side of what is profit, could you analyze the tax law to show the absence of tax shelters?
Well, they're definitely there, so I don't think you could. But what you could do is, if the IRS could anticipate this somehow, or get their own shelter generating software, they could proactively shut things down. They have a list of transactions that they say are forbidden. These are tax shelters. You could add things to that list before other people even came up with them. You could at least know where to look if you had your own program generating these tax shelters. If it were possible to do this, I would think it would be absolutely critical for the IRS to get some version of this as well. If private industry has it and the IRS doesn't, then good luck. It's not a good outcome.
Another question?
It's well known with the law that an overly literal interpretation of the law leads to gamification, absurdity, and injustice. And I'm curious about your thoughts about reducing the law to a formal mathematics could lead to gamification, absurdity, and injustice. Doesn't there need to be an inherent flexibility in interpretation of the law rather than a formal thing may lead to a rigid interpretation of the law that causes more problems? So I'm curious on your thoughts on that.
I absolutely agree with that. I think it's really important that even a formalized law would retain ambiguities, at least in the meaning of terms. The other advantage, just speaking to the gamification point for a moment, another advantage to ambiguity that I didn't mention is exactly this point, that if you have rules, it's very easy to know how not to break them. So for example, In legislation against tax shelters, the code intentionally leaves a key provision, economic substance, ambiguous. They absolutely want a standard there instead of a rule. If you make it a rule, it's far too easy to figure out how to get around it. But I don't see formalization as inconsistent with retaining this kind of flexibility and ambiguity, because terms could remain ambiguous. And what you could think of what the formalization is doing, a couple of things. One is, to the extent that the rules are fixed and known, it would make compliance easier. And the other is, it would be a roadmap that takes you from standard to standard in some sense, or ambiguity to ambiguity. It would highlight the provisions where there were flexibility, and you could focus on that instead of spending your time making your way from one of those provisions to another. But I certainly agree that you do not want a law that is all rules as opposed to standards, for exactly the reasons that you mentioned.
Thank you.
Hi, I have a clarification question and an actual question. So the first one is you're proposing the formalization of laws, and are you proposing that Congress passes a law written in English that is then formalized into formal mathematics, and then the ambiguities in that are then done away with effectively back in English law, or are you suggesting that the formal mathematics become the law itself?
I am suggesting. So I'm not suggesting that the formal mathematics become the law itself. I would imagine the formalization having the same weight as legislative history. So currently, the weight that legislative history should be given is highly contested. Some people take the position that legislative history should have no weight at all. Justice Scalia was most famously associated with this position. Other people take the position that legislative history gives us useful information about the meaning of a statute. You have exactly the same arguments about the formalization. Go right ahead, right? We have all those arguments set up. Let's just, let's have them about this. But it was additional information that you could use however you would use legislative history. And again, the ambiguities don't need to go anywhere. You can formalize, and you're like, oh, there's one, there's one, there's one. That's fine. So no, I would definitely not imagine that in what I'm describing, the formalization would become the law. So in this way, that's different from, for example, blockchain, right? Where what you have there is, in some sense, the law, or at least, contracts in general are kind of amazing because they're sort of like laws that individuals can write themselves that are then enforced by the government. So this is a thing about contracts in general. And if those contracts are on the blockchain, then you could say the formalization is the law in the sense that that's kind of what contracts are. But that's not what I'm just imagining here.
Thanks. So when I mentioned your talk to a friend of mine who's pre-law, he immediately jumped up and said, "Hang on, you can't do that because tax law and statutory law is litigated." And so in a world where I guess litigation happens, and all of a sudden there's formal specification of the law and an actual English version of the law, like what does litigation end up looking like?
Well, so let me first say, litigation does happen. Litigation is, let me take tax as the example, but you could use this really with anything. Litigation is vanishingly rare compared to the number of, let's just say, for example, tax returns, or even setting aside really simple tax returns, like even contested tax returns, litigation is incredibly rare. So that's one thing. The other thing is that litigation often is around some kind of ambiguity. So presumably litigation would continue, and there will be ambiguities will remain even if we have a formalization. You sort of continue, the litigation continues, and if a court holds something that is inconsistent with the formalization, it's time to revise the formalization. If you're working with that understanding of the law, even if you feel strongly the court is wrong, if that's the law now, then you better revise, or you're going to be in an unpleasant situation. So I think the formalization, if the formalization is consistent with litigation.
This is a really interesting talk. Thanks so much.
Thanks.
Thank you for coming here, actually, to a club of people who are very formalization oriented, because you're not somebody from a discipline that has, over the last 40 years, you've alluded to that one, actually not been a big fan of formalization. So computational law is very old, and I've had the pleasure of working with some of those aspects myself. And the last experience was 10 years ago is that we got the same ones, like you can't formalize the law, like, you can't do that. But looking at this one in context of enterprise systems, we found out actually the law has wonderful, actually, formalizable parts. Namely, usually the implications, which is the logical part of it, is actually quite clear. But it, and then the feedback is then, but you can't establish facts by formalization. Well, whoever wanted to do that. So whether a patent is obvious or not is nothing like that has something to do with logic. I mean, but the implication usually that says, like, if it's obvious then it's invalid, it's not like, there's not a lot of fuzziness about that. Like, maybe it's Tuesday and it's in eastern Texas, so maybe it's not, it's valid anyway, right? So that's usually not the case. So do you think actually there is a possibility of formalizing the logical parts of law? Usually these are the inferences, not the fact-establishing parts, which are human process. That's the first question.
Yes, so I do, and I want to actually, before I get to the question, I want to go back and focus on your comment that computational law is very, very old. It is, and it keeps popping up, and really, and I always, I associate the beginning of this really with Lehman Allen, who was on the law side of things. And there was a school of thought in the early 20th century that, it was all going to come down to logic, and obviously that didn't pan out, and that's fine. But it keeps popping up, and it's been popping up for a long, long time. And and it's always the objections that you mention. And I guess I'm very hopeful or optimistic that we're reaching a point now where there is so much focus on what computers can do and what artificial intelligence can do that maybe finally people are going to be receptive to this. And lawyers and law professors are very resistant to, or have historically been very resistant to, anything that smells like math. Why did they go to law school? Because they couldn't do math, right? That's why they went. So, and to the extent that this is going to change, one thing that I really hope is that the pipeline of people who are going to law school will change. There's no reason, if this is something that's going to happen, and we can get people who are interested in computer science to go to law school, there is a whole field of study that could happen if we get the right people doing the studying. And so yes, it keeps popping up, but maybe now is the time. And in terms of formalizing the inferences, exactly, right? We can formalize the inferences and leave the gaps of the fact determination to, people can do that. You can think of it as analogous to what happens in a courtroom, where you have a jury that decides the facts and a judge who decides the law. So you can sort of take that analogy and think about doing that with the law. So yeah, I think absolutely, and and I definitely appreciate your mention. This has been going on for a long time, and I imagine it's lighting a match, and eventually the fire is going to catch, and maybe now is the time, and then we burn it all down. No, that's not. I realized that wasn't a good analogy as soon as I started.
Thank you.
Yeah. Okay.
We'll take another question, but since we have the lightning round coming up, let me ask the people from the lightning round to line up over here, and the rest of us will just ignore them for the moment.
Yeah, so my question is, if people here were interested in starting work in this area, right? I think most of us aren't lawyers, and most of us are not likely to go to law school. So what would a computer scientist need to learn in order to be able to work productively in this area?
I think probably the most useful thing is to work with someone who is a lawyer. I'm a big believer in co-authoring, and it seems if you find someone who has the other part of the knowledge that you need, then just go ahead and work with them. I don't think the fact that you're not a lawyer should in any way slow you down. There are centers. Stanford's Codex is Michael Jensereth, who's a computer scientist who works on computational law. For example, there are centers that are involved with this. He's not the only one. Making connections with those people, and then who will then make connections with lawyers or law professors, I think is probably the most efficient way to get involved, and not to feel that there's any knowledge barrier, because you can always find someone else who has the other part of the knowledge.
Thank you. Great. Let's thank Sarah again very much for